Hi, everybody. Thank you so much for joining us today. I'm Michelle Morris from Consolidated Planning Group. I am so glad that you are all here and that we are able to share this great information today with attorney Alison Packard. Today, we're going to be focusing our topic on why do you need a financial advisor who specializes in special needs topics and a separate attorney who focuses on special needs topics. Why is it so important that you have both of these areas covered in your planning? Um, Again, I'm Michelle Morris. We should be here for about an hour today. Because we are in webinar mode, we cannot see you or hear you, and we're not going to unmute people. So please, if you have any questions or comments, we would love for you to put those in the chat box today. That's the easiest way for me to present information and watch Alison and watch the chat box and get all those questions answered. So please put your questions and comments in the chat. Feel free to have a drink or a snack. We can't see you anyway. And after today's webinar is finished, the live portion, we will send you an email later today with a link to the recording as well as the slides that we go over. So you will receive all of this information in your email later today. So first of all, I want to talk a little bit about Consolidated Planning Group, who we are and why you should be listening to us in the first place. We are a holistic special needs planning firm. We're located just outside of Houston, but we serve families that are located all across the United States. We mostly focus on Texas, and today's legal topics are going to be focused mostly in Texas. So if you have questions from other states, please feel free to put those in the chat. If we know, we will let you know. If we don't know, we can find answers for you. We have over 30 years of experience in planning services, financial services, life insurance, securities, all of those areas. We are members of the Special Needs Planning Academy. We are National Social Security Advisors, and I am a chartered special needs consultant through the College of American Financial Services. So even though, like I said, even though we are based in Sugar Land, just outside of Houston, we can help you no matter where you are. Families come to us for things like protection planning. What happens if you pass away early or if you become disabled and you can't work anymore? We talk about lifetime care plans and helping you think about the cost of care for your loved one for the rest of their life, even after you're gone. And that's the most important thing, right? After you're gone. We talk about transition planning. We do ABLE accounts. And in general, we are here to advocate for you and to educate you because we've been through it. And as parents of kids with disabilities, we know that you are in the thick of it and you have a lot on your plate. And so we're here to try to make things easier for you. Out of all of the financial advisors across the United States, and there's over 263,000 of them, out of those 263,000 financial advisors in the United States, fewer than 200 of them focus on special needs planning like we do. Many advisors might be able to do it. They do it once in a while, or they do it on the side of their true business. But for us, about 97% of our clients have kids with disabilities. This is all we do every single day. So you are truly in the right spot when you're talking to us and when you're talking with Alison Packard. Because Alison, if you wouldn't mind telling us about yourself and how long you've been doing this, you are truly an expert in this field that we recommend quite often.
Thanks, Michelle. Yeah, I've been practicing law for many years. I've had about 30 years of experience. I did take about 10 years off to stay home with my daughter who has significant disabilities. And so to be quite frank, most of my true experience where I really get an edge on what's going on comes from the experiences I have as a mother. So, my legal practice just does focus on special needs estate planning, special needs trusts, guardian alternatives when they're related to somebody with some special needs. And so that is my legal practice. But again, my worry and I think my perspective comes from being a parent I have a 30-year-old daughter with special needs who is doing great but has pretty significant needs. I'm in San Antonio and I'm with the Packard Law Firm.
Thank you so much for that brief introduction about yourself. So do you want to give us your legal disclaimers?
This is a standard disclaimer whenever I do presentations. Just want to remind everyone that this presentation is not establishing an attorney-client relationship, and I'm not giving specific legal advice for your particular situation. We're just talking generally. This is just educational purposes only.
Yes, yes. And if somebody wants to contact you, and do you do a free consultation? Do you speak with people a little bit first about yourself and your services? How does that work?
Sure. So at my practice, generally, I charge $100 for a consultation. If you say, you just have a few questions, a lot of times I just make phone calls. That's always an option. If you need a sit-down consultation or a lengthy consultation, I do charge $100 fee for that. And that's basically to manage my schedule because I've booked up about at least 4 to 6 weeks out. So if it's just a quick question though, or a follow-up from today, my email address is on this slideshow. You're welcome to email me or call me, and I'm happy to just return a call and go over a few basic things. But if you need something more formally, then I'll have you contact my office and schedule an appointment.
Perfect, perfect. So as the financial advisor on the call, I like to say that, we take care of the money side, helping you understand the benefits that are available, and just, giving you all of that financial advice, considering that we have to look through the lens of understanding that your child might not be able to be completely independent. They might not be able to hold a full-time job that's going to be enough to pay all the bills. They might not be able to live without some sort of care. So we help you with the money side of things, whereas the attorneys like Allison, she focuses on the paperwork and legal framework side of things.
Yeah, that's right. My job is more surrounded by the documents that we need to put in place, and we'll get into more detail of that. Setting up a special needs trust, but how much money needs to be in the trust, that's where I would kick it back to a financial planner to really work with you to give you the advice on how much money needs to fund the trust, what are the Social Security benefits that will be available, and how much will be needed on a yearly basis. And so I think it's a great relationship to work with both the planner and the advisor, financial advisor.
Yeah, and that's the basis for, if you think of a pyramid, the base is that legal framework. That's the most important thing that you have to have in place. Because if you don't have the legal framework in place, everything that you build financially above that, it could crumble. If you don't have, the next level up we call risk management. If you don't have life insurance and you have some kind of big financial hit, it crumbles everything else in your pyramid that goes above that. If you don't have the legal things, it's going to not have that solid foundation that you need. But we can provide you with that financial advice. So financial advisors typically charge either fee-based or commissions-based or kind of a blend. Um, we charge a one-time fee for putting together your plan. And we do offer a free consultation to anyone who is interested, and we go through our pricing, we go through what questions you have. One thing that we do that I think is extremely beneficial for parents is that we help you figure out that future cost of care estimate, where we look at, We kind of think that while you're still here on earth, taking care of your loved one should be part of your budget. Just like your retirement needs, your groceries, your utilities, you're taking care of your family. It's part of your budget, your monthly, month to month. But once you pass away and you are not here to pay those monthly budgetary items anymore, we need to make sure that money is set aside for your loved one in a special needs trust or in their ABLE account. Those are the two places where your loved ones can have money. And we try to help you figure out how much do they need in that special needs trust. If I pass away, my loved one is going to go to a group home and they need part-time care. That's one thing. If my loved one is going to go live with relatives, that's another whole financial picture. If I want my loved one to go to like Marbridge or 29 acres and have full-time care in a place like that, that's a totally different financial picture that needs to be looked at. So we help you with those future cost of care estimates. We make sure that your money is in the right buckets so that it does not jeopardize any of those very valuable state and federal benefits. You're filling out all this paperwork to apply for SSI and SSDI and Medicare and Medicaid. You're waiting 20-ish years to get your waivers. You don't want to accidentally cause your child to become ineligible because you put money in the wrong spot, So we help you understand all of that. We forecast your ability to retire and still be able to provide care for your loved one by looking at your future income and expenses and assessing all of that information. And we provide you with advice on what financial vehicles are going to help you reach your goals. And that goal, for the families that we work with, typically includes leaving enough money to care for their loved one. Sometimes families leave money to charity. Sometimes they leave money equally to all their children. And for us, those families need to leave money to that special needs trust. So we help you think about how much life insurance do you need? What do you have in place? Is that going to cover you? Is that going to be there for you? We use third-party asset managers to help manage your assets and your portfolio. We help with that transition planning. There are three main transition periods in a child's life, I think of when they have a disability. And Allison helps with some of these transitions, and we help with some of these transitions, but it's so important because the first one, when your child turns 18, all of a sudden they are a legal adult in the eyes of the law, right, Allison? Do you want to talk a little bit about that threshold of turning 18?
Yeah, turning 18, one of the big decisions we always have to look at is, and I'll use my daughter as an example. When my daughter turns 18, is she capable of making decisions on her own? Is she capable of signing a power of attorney? Does she have enough mental capacity to understand that legal document? Or do I need to go to court and get a guardianship? I have a right as a parent to make all medical decisions for her up until the age of 18. But once she's 18, I lose that right and to make other decisions for her. So if I feel like my child doesn't have the capacity to make her own decisions, I can go to court and become her court-appointed guardian. Um, we always look to see if there's an alternative before we jump to guardianship. A guardianship does remove a lot of rights, and so we don't want to just jump immediately to guardianship. And so we want to look at alternatives such as, could this person sign a medical power of attorney, a financial power of attorney, a supported decision-making agreement? Are there ways to avoid the guardianship? And in some cases, it's very clear that we do not need a guardianship. In other cases, it's very clear that we absolutely need a guardianship. And then there are a lot of cases where we're right on the border. Maybe your child has some capacity, but is a little vulnerable. We can do limited guardianships. We don't have to remove all rights. We can modify a guardianship to be specifically designed for that individual. And sometimes that's the right solution. Sometimes the solution is to try one approach, maybe attempt to use some of these other alternatives, and if they don't work well, go back for the guardianship. But yeah, that's the big issue. Besides, oh, let me say also Social Security benefits. That's another huge factor when someone turns 18. You know, up until the age of 18, parents' income and assets count for their children as far as SSI and some Medicaid, not all Medicaid waiver programs, that's not the case, but for a lot of the programs, the parents' income and assets count until age 18. SSI is a very common one in our world. And so a lot of times at age 18, that's when we apply for SSI, help our children apply, because that benefit now will not look at the parents' income and assets. So there's a lot going on during that 18 range transition period.
Yes, that transition is a big one. But there's also the transition periods, you know, when they graduate high school. And now, you know, you don't want them to graduate to the couch. So what comes next? And then there's a third transition period, I feel, when the parents pass away and the children have to be in their new living situation, whatever that's going to be. And if you can make that transition easier on them by having your children in their residential community or living with family or wherever they're going to be for the rest of their lives before you pass away, I mean, that would be ideal, of course. You don't always see it coming, but if it's possible. But the three big transition periods, I feel, and having those all set up ahead of time and thinking ahead about it is key to helping you sleep better at night. We can help
That's
you.
right, Michelle. Oh, I was just going to add, I will say that transition period you just mentioned after parents die, as a mother of a child with disabilities, this is the one that worries me the most. How is my daughter going to do? You know, is she provided for? Will these Medicaid waiver programs still work for her? Will she remain eligible? Will she have what she needs living wise? You know, was she in the right living situation? By far, to me, that is the one that worries me the most because I'm gone. And so that's where special needs estate planning attorneys can really help take care of those types of issues in combination with the financial planner.
Right, exactly, exactly. So yeah, we can set up ABLE accounts for you. We provide advocacy. We share resources and referrals. We can help you think about appropriate funding for the future for your loved one and for your retirement and all of that kind of stuff. Strategies on SSI and Medicaid, SSDI, Medicare, and the waiver program. Some people don't need them, don't want them, don't want to jump through all the hoops of SSI to be able to get that payment. And we understand that, you know, that's true in some cases. In most cases, those benefits are very important to families. And keeping Medicaid, of course, and not ever losing that waiver program. And then we can also do a Social Security maximization so that we can maximize those benefits that you're going to be getting for your family. So I do see a couple of questions popping up in the chat box, and I want to get to them. But I do want to make sure that, you know, Allison, you have a chance. So why don't you go through, we'll do a couple more slides and then get into some of these questions.
Okay, perfect. Yeah, as I mentioned before, the special needs attorney is going to be focused on estate planning documents, you know, making sure there is a proper special needs trust in place so that government benefits are not lost. The last thing we want to do is wait 20 years to get on that Medicaid waiver program and then lose eligibility because estate planning wasn't done. And so special needs trusts, as we mentioned, are really the key. And we can get into more detail of that later if we have time. But ABLE accounts also work. So we would talk about the differences. There's limits on how much can be in an ABLE account, two kinds of special needs trusts. One type of special needs trust has a Medicaid payback, one does not. So we would talk through the different options, make sure there is a good will in place or a revocable living trust, something to make sure the assets get to where they are supposed to go. Of course, the special needs planning attorneys are also in court. Besides the guardianship, which is all court driven, besides that, sometimes we're back in court after a parent has died and left an inheritance to a child. Maybe we're asking for a trust to be created after the fact. That's not the ideal way to do it. It's a bunch of legal fees, and a lot of times the beneficiary of the trust ends up with one of those first party trusts with a Medicaid payback. So we much prefer to take care of special needs estate planning on the front end before the parents have died, but sometimes we do some work on the back end as well.
And it's so important to get things set up correctly from the beginning, because going back and revising orders and making amendments and all of that stuff, that's going to cost more, right, in the long run.
Yes, absolutely. I'll give you an example, a will. You could have a standard will, and the will can be reformed in Texas. So if there's not a proper special needs trust in place, we're fortunate enough to be in a state where we can go back and ask for the will to be reformed. But that's more legal fees. If by the way, that only works for a will or a trust. If there's life insurance beneficiary that was not where life insurance proceeds were paid to an individual with special needs, that we can't reform. So some things we can reform, some things we just have to accept the money and go from there, usually creating a first party trust.
Yeah.
What is even more concerning is when there's no will in place. And do you want me to talk about that a little, Michelle?
Sure, absolutely.
Yeah, if you'll go to the slide on airship, well, actually go to the slide that says where does my property go after I die? Oh, this slide just shows what
Yeah,
estate
let's
planning
talk about
is.
this one a little bit.
Okay, all right, well, I'll be patient, we'll get to it. Okay, estate planning is basically just planning for the transfer of your wealth and your assets when you die, and also managing your assets upon disability. What that means as far as the disability angle, if I have dementia or Alzheimer's, I may be still alive and I need to make sure something is in place for someone to pay my bills, for someone to make sure that everyone is provided for, that I have what I need. Typically that is related to powers of attorney, or maybe a typical revocable living trust. So there are some documents that we can create to make sure that your assets will be managed if you are still living but disabled. And then, of course, the big one when we think of estate planning is where do our assets go when we die? And if you'll go to the next slide, Michelle, the first thing is if there are non-probate assets that have a payable on death beneficiary, maybe a life insurance policy, a retirement account, then obviously those assets will pass according to the named beneficiary. If you have a trust that is funded with assets, then we look at the trust document to see what happens when the person who created the trust dies, where the assets will go. If we're looking at a will, then what we do is we probate the will. That means we take it down to the courthouse. A lawyer has to be hired, and it's very simple in Texas. It's not a big deal, but it does require a court hearing and attorney's assistance. And we get an executor appointed to follow the terms of the will. And so if my will says I have 4 children. So if my will says, give this amount of money to these 3 children and my daughter's share goes to her special needs trust, the executor follows what's in my will. If there is no will in place and you have a child with special needs, it gets complicated and is not always what you want it to be. So there are more expensive probate proceedings that when someone dies without a will in Texas, we need to have an heirship proceeding. And that is where, if you'll go to the next slide, that is where an attorney ad litem gets appointed to find out who all the heirs are, even when everybody knows who the heirs are, who's legally entitled to inherit from the person who has died. There still needs to be an attorney ad litem. The person who's trying to get the heirship done has their own attorney, so you're paying for 2 attorneys. And then you find witnesses to go to a very quick hearing and explain about the family background, and the judge signs a judgment declaring heirship. And that paper, that judgment identifies who gets the assets of the estate. And it's based on Texas law. And in many cases, Texas law is exactly what you would want. In some cases, it's not. So you should just know that, for example, if you have a child that is born from a different parent than the person you're married to, it may not be, your assets may not go where you want them to go. I don't know if I explained that very well. So for example, if you're married for 50 years to the same person, but you had another child not with that person to whom you're married, then your community property will not pass to your current spouse or the spouse you were married to at the time that you died. Your share of community property, your half share, will pass to your children instead if you have children with somebody else. So
And
again, that's just an example. Oh, go ahead,
that could
Michelle.
be a big problem if it's a child with a disability and all of a sudden they get this huge um, inheritance and they lose all of their benefits. So things have to be set up correctly.
That's exactly right. After you have the heirship determination, you get an administrator appointed to administer the estate. Hopefully that will be an independent administrator that isn't very, it's not as expensive to manage it compared to a dependent administration. But that administrator will have to distribute the money according to the heirship determination. And that heirship determination is not going to give money to a special needs trust. So typically what happens is the administrator has to go back, ask permission to create a special needs trust. At that point, it has to be one of those first party trusts with a Medicaid payback. So it's just not ideal. I would say one big take home message would be if you have a child with special needs, it is even more important than ever to get your estate planning done because you want to be in control of where your assets go, and hopefully you will have it set up to go to a special needs trust.
Thank you so much. So if you don't mind, Allison, let's get to some of these questions in the chat box and just get through what we've got there while we have this slide up.
Okay.
So Jennifer wants to know, how do you convince parents that are exploring guardianship that it's important when the doctors and service providers are still allowing the parents to make the decisions anyway? Now, I know that guardianship is not the be all and end all when it comes to doctors' offices, but of course, this is a very big concern that the doctor talks to the parents. What can we do to protect ourselves there?
Yeah, and that is common, by the way. A lot of time doctors will just work with the parents. What I typically talk about is to think a step ahead. What happens when you're gone? Because a lot of times that very natural relationship where the doctors sort of fudge the lines and just work with the parents and don't require guardianship paperwork, even when there's very significant disability. A lot of times that kind of setup will not continue once the parent is gone. And so I work with a lot of siblings who are trying to get guardianship because suddenly mom and dad are not around and the doctor won't talk to them. They've got problems all over the place trying to sign the right documents. And so they frantically come and try to get the guardianship. And by the way, we can do emergency guardianships, but it is very expensive. They're called temporary guardianships and they only last 60 days. And basically you go through a whole lot of expense to get a temporary guardianship, and then you have to go and get the permanent guardianship, so you're paying twice as much money. So
Mm.
one of the factors I would say is to think ahead when you as a parent are gone. Is there going to be a problem? Now, if there's not a problem, if your child has capacity to speak for themselves, then maybe a supported decision-making agreement will be sufficient, coupled with powers of attorney. But if there's significant disabilities, guardianship is going to be safer. I've also done some temporary guardianships where someone is in a hospital. I did one recently for someone who needed a treatment that the doctor, the surgeon, was just not comfortable agreeing to without somebody with the right legal authority to sign the consents, because it was, they're going to obviously keep your children alive, but if it's something that the doctor's uncomfortable with, sometimes at that point you end up racing and trying to get a guardianship because of particular treatment. Everyone's uncomfortable doing that without a guardianship. Does that make sense? So those would be the two arguments I would say: is think ahead of when you're gone and think about the emergency situations. Is that going to potentially cause a problem?
Fantastic. Thank you for that bit of advice. Now, if I got guardianship of my child and that attorney that set that up for me retires or changes jobs or leaves the state, or if I move out of state, what do I need to do to make sure that that guardianship is still good?
Guardianship must be in the county where you're living. So if that child under guardianship moves out of state, you need to transfer the guardianship to the new state. For that matter, you need to transfer to the county you're living if you just change counties. But there's no problem if the attorney's not around. The necessity of the attorney really depends on if you have a guardianship of the person only or guardianship of the person and estate. Guardianship of the person is making medical decisions, choosing where someone lives. Once you're appointed as the guardian, you just need to do an annual report, and quite frankly, you don't need a lawyer. It's very simple to do that on your own. Just fill out the forms and turn them in every year to have your papers renewed, your guardianship letters renewed. If you are guardian of the estate with authority to manage money, that you do need an attorney. So if your attorney is no longer there, you need to find another attorney. And I would say in most counties, they require you to do that accounting, that annual accounting through an attorney. There are some counties where they fudge a little bit, but not many.
But it shouldn't be too difficult. And the new attorney can just review the document and make sure everything is still good, right?
Absolutely. I mean, it happens all the time. An attorney who represents you retires or passes away, and a new attorney takes over. It's very common.
Okay, fantastic. Um, so what, go ahead and go through some of these if you don't mind, and then we can talk about one big topic that we always have to talk about is divorce. So let's tackle divorce after you get through these couple slides.
Okay, this slide is just explaining again more about what the special needs estate planning attorney does. And that is going to be really looking at what's going to happen when you die, where are the assets going to go, do we have, for example, I would say, well, what kind of benefits is your child receiving? Are they on SSI now? Are they likely to be on SSDI in the future? Do they need Medicaid waiver programs? Depending on the answers to those questions, it might change what type of documents we draft. In most cases, we're going to do a special needs trust just to allow for eligibility of those types of programs. But in some families, we do a revocable living trust. The way I look at it is a lot of our kids, even if we don't need certain government programs, a lot of our kids are vulnerable to someone sweeping in, taking advantage of them. And so typically, if you have a child with disabilities, you're going to want some kind of trust in place where somebody can manage the assets so that they won't be taken advantage of. And if we're going to do a trust anyway, a lot of times the special needs trust is the safest way to go to allow that person to be eligible for government benefits. Special needs trusts, again, are more restrictive, but that's typically a good solution. And so we talk through those kinds of documents, make sure there's a will in place, powers of attorney. We talk about trying to avoid probate if we don't need the probate procedure, and that has to do with deeds and things like that. And so those are the types of conversations we have, and lots of discussion about long-term needs, housing and those kinds of issues.
Yes, yes.
And this slide, oh, I'm sorry, this slide just outlines your typical estate planning documents. Wills, trusts, we've mentioned, deeds. You can have transfer on death deeds. We can deed assets to a trust. A lot of times a house is deeded to a special needs trust when the parents die. So I already mentioned the powers of attorney are important. There's also documents where you can declare a guardian for your child or for yourself if you need a guardian. So this is just a list of your typical estate planning documents. Not everybody needs every one of these documents, but I'm a big proponent of having a will in place. Because sometimes you think you won't need a will, you think you can avoid probate, but there's an asset you didn't think about, or maybe you were killed in an accident where we need an executor to manage the estate. Maybe there's a lawsuit. And so I'm a big proponent of a will. And for this audience, I'm a big proponent of special needs trust. And then, of course, the powers of attorney. You can have a lawyer help you. These are really standard documents. So sometimes you can even find these online. And if you need a reference to some sites where you can get the standard powers of attorney documents, I can give that to you.
Perfect, perfect. Let's talk a little bit about divorce while we are here. I see a question in the chat box that says, I'm divorced and I haven't set up anything regarding special needs trust or guardianship. Should I work with a special needs trust attorney? and my divorce attorney to revise my divorce documents. I think you should definitely work with those people and a special needs financial advisor to help you as well. From my point of view, what I see, of course, is the special needs trust being an issue and being a concern. Child support, and I'll let Allison talk about the child support. But one thing that we look at from the financial planning perspective is how can each parent leave money to the trust to be help take care of the child. And usually that is done through life insurance. So if each parent gets maybe the same amount of life insurance that's going to flow straight into the special needs trust when they pass away, that's a great way for each parent to still contribute to your child's future. And if they're both doing it, it's equal. They shouldn't have too many complaints. Um, Allison, tell us a little bit about the special needs trust and well, especially the child support issue.
Yeah, so when in Texas, we do have lifetime child support available for an adult who it has substantial disabilities. Basically, they require personal care. Let's see, what's the substantial care, personal supervision because of a disability that existed before the age of 18, and they are incapable of self-support. So if you have a child and you're divorced and your child has those significant disabilities, lifetime child support is available. However, child support that is being paid for the benefit of someone over the age of 18 is considered income to the 18-year-old or 18 plus, the adult. So even if the child support check is being made out to mom or being made out to dad for Social Security purposes, that's considered income to the child. And so the effect of that is if you don't go back to court and have the child support paid to a special needs trust, the income will usually disqualify the person with disabilities from receiving SSI. So for example, if there is $1,000 being paid in child support, that counts as $1,000 per month to that individual with disabilities. And if we're talking about SSI, the maximum SSI is $943. So if you take the $943 maximum, subtract the child support that's being paid, it subtracts the amount the child support reduces the SSI amount dollar for dollar. So if you have 943 minus 1,000, there's nothing. There's no SSI, which means there's no related Medicaid. Now there are other Medicaid programs available, but the way you avoid that problem is you work with your divorce attorney and you have the family law court, that judge can order someone to create a special needs trust and irrevocably assign child support to the trust. And then that income does not count as income for your child. Now, it has to be done by court order. You can't just take your child support and move it yourself to the trust. You need to turn in your court order to the Social Security Administration along with your trust document, and the judge needs to order the creation of the trust and the irrevocable assignment of the support. But if you do that, then it's fine. There's no problem at all. That kind of trust to receive child support must be a first party special needs trust. That is the kind of special needs trust where upon the death of the beneficiary, Medicaid gets to be reimbursed for all the Medicaid payments made over the child's lifetime. So that's the only kind of trust we can use for child support. So in effect, what that means is a divorced couple, a lot of times will have a first party special needs trust for the child support, and then they will create a second trust, which is a third party special needs trust for all of the other assets, because there's no Medicaid payback on the other assets. And so in some situations, the divorced couple can use the same third-party special needs trust. So one parent can leave assets to that third-party trust, and the other parent, even though divorced, can leave assets to the same trust. A lot of times parents can work together on that and use the same trust, and sometimes they create their own. The big issue on that is, can you be in agreement on who's going to manage the assets and where the remaining funds go when your child with disabilities passes away? So sometimes it works to just have one third-party trust that everyone works together to fund, and sometimes we need multiple trusts. I will say one last thing. We mentioned ABLE account because there's some misunderstanding on that. You cannot have child support paid to an ABLE account. Well, you could do it, but it will still count as income to your child. The only way to have the child support not count as income is to go to a first party special needs trust.
So
I
you
hope
mentioned
that answers.
the Medicaid reimbursement clause on the first party special needs trust. So let's talk a little bit deeper into that. So what happens if it's not a first party trust and the child passes away when there's still money in there? How can you leave it to a beneficiary that is not a disabled child? How does that work?
Yeah, sure. A third party special needs trust, you're in complete control when you draft the trust and work with your attorney to say where you want those funds to go when that child dies. So, as I mentioned earlier, I have 4 kids. So, when my daughter passes away one day, whatever is left in her third party trust is going to go to her 3 siblings. If any of them have died before her, that sibling share will go to their children. I can leave it to a nonprofit organization, I can leave it wherever I want. My third party trust is revocable, so I can change that over the years. And it's completely flexible, whoever you want the remaining funds to go to. It's the first party trust where you're stuck. You've got to have Medicaid reimbursed first. Now, if there was no Medicaid or it's a very small reimbursement, the remaining funds can pass on to whoever you want. But a lot of times, for those of us in this world on this call, a lot of us are looking at Medicaid waiver programs. And Medicaid waiver programs will usually give us a very high Medicaid payback on our first party trusts.
So I mean, you might have kind of, what happens to a joint revocable living trust when the first person dies?
Well, that's going to be just based upon the document itself. So revocable living trusts, they can be drafted in lots of different ways. Sometimes the trust split in two. Sometimes the trust just continued to operate the same way for the surviving parent. So that's going to be very individual based on what kind of setup you want to work out with your attorney. And then typically when both parents are gone, that's when the revocable living trust can explain some assets might go to a special needs trust, some might go to another child, whatever you want to set up in that is fine. Very
Okay.
easy to draft according to an individual's wishes. Very, very easy to modify.
So I think that one question that we get the most often, the legal question about what happens when people die, that I don't really know how to answer, and you will, is surrounding, when there's no successor guardian, there's no trustee, there's nobody that people know that they're going to trust their children with or their money to. Consolidated planning group will not act as an administrator or a trustee for our clients. Um, Allison, do you want to talk a little bit about in those situations, what do people do?
Sure. As far as the trust goes, it's if you know you're going to have a problem, there's nobody you really trust, you might consider a pooled trust. A pooled trust is a special needs trust that's managed by a nonprofit organization. In Texas, we have a wonderful pooled trust with the Arc of Texas Master Pooled Trust. And what they do is they have sub accounts for many people. They will manage those assets, and it's still a special needs trust. And so the money does not count, keeps everyone eligible for government benefits. Sometimes what we do is we have a clause in a trust document where maybe I want my other son to be the trustee, but if he cannot do it anymore, then it could go to a pooled trust after that. Or maybe I give him power to appoint someone else. So there's a lot to talk about best options. If you have very significant assets, then a corporate trustee is often a fabulous idea on a special needs trust. That's where you have a bank or a trust company that specializes in special needs trusts, managing the assets. Both the pool trust managed by the nonprofit and the corporate trustee are going to charge fees. And believe it or not, the fees are pretty similar. It's usually a very small percentage, anywhere from 1.2% to 1.45%. So both of those are going to charge fees, but the corporate trustee is not going to accept the trusteeship unless you have quite a bit of money. And when I say quite a bit, in my area, I live in San Antonio, a lot of them want about $500,000 worth of assets. Now that could be a house included, but a lot of people I work with, I'd say most people I work with don't have that kind of wealth to leave to a trust. And so if you're in that situation, the Arc of Texas or another type of pool trust is often a good idea. So we can always find a trustee. That's not a problem. if you don't have the document laid out in a way, if we don't have it naturally passed to another trustee, sometimes you have to go to court to get a new trustee appointed. As far as the guardianship goes, if there really is not a family member available, what will happen when you die is the judge will appoint a guardian ad litem to go look for relatives to see if there's any relative out there who could take this on, because we always want to defer to the family members if possible. If there is no relative, then we look at private professional guardians or a guardianship program. A lot of counties have guardianship programs. Now they manage a lot of guardianships. I'm not going to lie, it's a lot of work. We always prefer to have a family member, or in a lot of cases, a private professional guardian will be able to provide the attention for someone who's on Medicaid. They can be paid through the Medicaid programs. Not a ton of money, but they get paid a little, $250 a month. And a lot of private professional guardians will take that on for someone who just needs a guardian to make medical decisions or sign documents about where to live. I hope that answered that.
Thank you so much. We talked about corporate trustees. Now, I know that certain banks have corporate trustees, like here in Texas, Cadence Bank, and I think Bank of Texas. Do you know of other good corporate trustees that you would recommend?
Oh yeah, there's lots. Again, in my area, I prefer the local banks. Maybe I shouldn't say this publicly, but I really like our local banks, like Jefferson Bank, Broadway Bank, Frost Bank, Cadence Bank is excellent. But the national banks have really great programs. Wells Fargo has a great program. But a lot of the bigger banks, they want about $1 million worth of assets. Argent Trust, they want even less. So it just depends on your local area, what's available, but there are definitely options. And if you think you might want a corporate trustee, you can also bring family members in to serve as trust protectors, which I think is great. So maybe I don't want to put this burden on my children to manage the trust. Maybe it's too much to ask them to be in charge of investing the money and paying the money. I can name a corporate trustee, but name my children as trust protectors or trust advisors, and I could give them power to fire the bank and choose a new one to see everything that's happening. So there's lots of ways we can tailor make an estate planning based on your family situation.
Perfect, perfect. Now, even though, you need an attorney to help you set up the special needs trust, a consolidated planning group can help you set up your ABLE account. These two things work very, very well together. It's great to have both the special needs trust and the ABLE account because, first of all, there are limits to how much you can put into the ABLE account, but there's not a limit to how much you can put into the special needs trust. There are limits to what you can spend the special needs trust for, but there are not limits really on what you can use the ABLE account for, as long as it is used for your loved one and can help them achieve a better life experience. So these two things go really well together. I kind of think of the ABLE account as a save to spend account. This is like your child's savings account at the bank. When they need money, they can roll it over into the checking account, and as long as they use it under certain parameters, it won't be counted against them for any SSI benefits or Medicaid. The special needs trust, like I said, it's kind of the opposite. There's no limit on how much you can put in. This is something that I want my clients to use in the future. Once the parents pass away and there's been all this money shifted over to the special needs trust, and the child is no longer relying on SSI benefits, that is where the special needs trust can come in to pay for things. So in either place, that money won't count against their government benefits. So that's really good.
Michelle, could I just add another thing to remember about the ABLE account is it does have a Medicaid payback attached to it.
Yes.
And so there are limits on what you can put into that ABLE account. It grows tax-free, just like a 529 college savings plan, which is wonderful. But remember, when the beneficiary of the account dies, in Texas, we have a Medicaid payback, which means the remaining funds will go to Medicaid. So if you're looking at a true savings account that's going to grow and grow, that would tend to lead you more towards a third-party special needs trust. I have an ABLE account for my daughter and a third-party trust, and I agree with what Michelle said. The ABLE account is a great way to have some money in there to grow. It can pay for a funeral before Medicaid takes the remaining funds. And so having some money in ABLE account is great. There are also restrictions. If a special needs trust pays for housing benefits for someone who receives SSI, the SSI is reduced by 1/3. If an ABLE account pays for housing, there's no reduction in SSI. It's a strange setup, but that's just the IRS created ABLE accounts, and they said that it can be used for qualified disability expenses, including housing. So there's no reduction in benefits. I was going to say, so a lot of us end up taking money from a special needs trust, funneling a little bit to the ABLE account to pay for housing. Again, there's lots of ways to use both of these together.
Yes, yes. And there's a question in the chat box, and yes, an ABLE account can be used to pay for legal fees, like setting up the special needs trust. It can also be used to pay financial advising fees if you choose to work with us. So your ABLE account can pay Alison Packard or her firm, or it can pay Consolidated Planning Group. There's no problems with that. Does the Medicaid payback include people who were never on Medicaid? No, they're only allowed to come back and claim up to the amount that they have given you, right, Allison?
That's right. It's a Medicaid reimbursement. So if Medicaid hasn't paid anything, there's nothing to be reimbursed for. It's just reimbursing them for what's come out. But be careful, because the Medicaid waiver programs come with a large reimbursement.
Yeah, they're spending, I think HCS waiver is over $400,000 per year that they're giving to families. So yeah, they're going to want to be paid back for some of that as much as they can. Can you move money from the first party trust to the ABLE account?
Yes, you can. And that's common. A lot of times that happens with child support that goes into the first party trust, and then it's moved to an ABLE account, and that's used to pay for some housing expenses in order to maximize SSI. And also an ABLE account it gives a little more autonomy to the person, the beneficiary of the account. So for someone who's a little higher functioning, it gives them a chance to manage their account a little bit more on their own. Special needs trusts are very restrictive on the beneficiary. So yes, it's very common to transfer the money.
So the
But
beneficiary
let
has
me
to
add, I'm
be,
sorry, Michelle, but only 18,000 per year. Remember,
yes,
there's a limit, 18,000 per year. So, and next year it goes up to 19,000, but it's limited, and you can only have a certain amount in there, 100,000 for someone who's on SSI, 500,000 if you're only on Medicaid but not SSI. So there are limits to what can be in there.
yes, absolutely. I was going to get to that because someone had just asked that. So thank you for getting that. Can funds be moved from an ABLE to a special needs trust?
No, it doesn't work that way in reverse.
Okay.
And it makes sense, because a third-party special needs trust cannot have assets that belong to the person with disability. That's why the child support has to go to a first-party trust. Other assets that would fund a first-party trust would be personal injury settlements and inheritance that came into the beneficiary's name. Once they have the money themselves, the person with disability has the legal rights to the asset. They can only move it to a first-party trust. And so third-party trust doesn't have the Medicaid payback, but all the funding has to come from third parties.
Perfect.
And Michelle, I forgot to say this. Let me also just mention, ABLE accounts can only have cash assets. Same thing with the ARC of Texas Special Needs Trust, the pooled trust. That can only be cash assets. If you're wanting to leave a house to a trust and you want other assets to go to the trust, that's got to be a standalone separate trust document. It cannot be a pooled trust or an ABLE account.
Perfect. Perfect. Um, So, oh, I forgot that we had this special animated slide. Do you want to talk a little bit about the about any of this stuff, or have we already kind of gone
We've
through?
covered most of this. The only thing I would add is that a first party special needs trust must be set up by the parent, grandparent, guardian, or the court, or sometimes with someone with enough capacity they can set up their own. But if you die and leave all your assets to your child, a lot of times we end up back in court setting up trusts. It's just very, very expensive. So if you can get all of, these kinds of estate planning documents done ahead of time, it saves some court fees. But the first party trust can take assets from any source, but the beneficiary must be under the age of 65. The third party trust on the next slide, the beneficiary can be any age and the assets can come from any person, but it just cannot already belong to the person with disabilities. I hope that made sense. So I could set up a special needs trust, not only for my daughter, but for my sister. And it could be stocks and bonds and a house, and whatever I want to leave to that trust is fine as long as the trustee agrees to manage it.
Fantastic. Is there a minimum for trusts?
Nope, you can have any amount of money in a trust. If you have millions of dollars, you could leave all of it to a trust. It's not like the ABLE account with limits. And this slide just reminds us all that if you're estate planning, you don't have documents that leave assets to the third party special needs trust, then a lot of times we end up with the first party trust with a Medicaid payback. And Medicaid is great and I'm very grateful to it, but I'd rather any remaining funds go to my other kids. And so a third party trust is usually the way to go. Again, we can reform a will, we can reform a trust within a certain time period, but that's going to involve lawyers and legal fees, and it's at the judge's discretion. So much better to get it done right from the beginning.
Right. And just because you put money in the first party special needs trust doesn't mean that you can't spend all of that before the person passes away. Um,
Absolutely.
you
Yeah,
know, if you,
absolutely.
I kind of try to tell my clients to use the first party first and the ABLE account, and then leave the third party special needs trust for later. Are there tax issues around the trusts that people need? We do have CPAs who focus on special needs topics who can help with that, but do you know offhand about taxes related to the trusts?
Well, trusts are always taxed. And so if you have a good CPA who understands special needs issues, a lot of times they know how to reduce the taxes. Again, you're not paying taxes on the whole amount of money in there, but as the trust grows, you're going to pay taxes on the growth, the income, and a good CPA will find a way to write off a lot of that income. So I do advise you to work with someone who understands special needs issues on all of
Yeah.
these areas.
In the ABLE account, when that money grows, that is not taxed. The growth
That's
in the ABLE account is not taxed.
Yes, that's correct. Grows tax-free.
Yes, yes. So you need both of us, definitely, both sides of the planning uh, for your future needs. I'm going to copy. I can't copy and paste. Allison, if you could put your contact information where you would want anyone in here to contact you in the chat box as I finish up. Um, we do webinars related to special needs topics several times a week. And hopefully some of you have seen some of our other webinars, but if not, we always put them on our YouTube channel after we're finished presenting. We do always email whoever has registered the information for that webinar, so that you can watch it later if you want to. But our firm is here to help you. We have a link here that you'll receive that will take you to our upcoming webinars on our website. So you can register ahead of time for any of those webinars, and you'll get the reminders, you'll get the information. This is the entire Consolidated Planning Group team. We have 4 financial advisors. It's 2 husband and wife sets. And then we have a great operations staff who helps us with all the paperwork and behind the scenes stuff that we do day to day. Like I said, we are located just outside of Houston in the Sugar Land area, but we work all across Texas and all across the United States. We do offer a completely free consultation. So you can either call me or email me directly and I can set it up for you. Or you can call the office at this these numbers here, and we can get you set up for your free Zoom consult. It is, like I said, completely free. It's over Zoom. We usually take 30 to 45 minutes to answer your questions about special needs planning. And then we go through how we work and what we do and the fees that we charge. And you can see from then if you're interested in moving forward with us, but at the very least, you get all of your questions answered from me or from Allison or Andy, financial advisors who focus on special needs topics. So I know that we probably missed some questions, but we are out of time. And that is why I would suggest that you reach out to either Allison for the legal side or me and Consolidated Planning Group for the financial side. I hope some of this has been helpful to you and that you all have a fantastic week. I know Thanksgiving was last week. It's time to get back to work and perhaps back on the diet train for some of us, me anyway. And happy holidays to all of you. So thank you for being here. And Allison, again, I want to thank you so much. Your counsel on this has been just priceless.
Thank you, Michelle. Thanks for the invitation. And let me just say, I know we did not cover everything, and I'm happy to answer the questions we missed if you want to reach out directly to me. And no charge for that. Just say, hey, I was at the webinar, I need to call you. So thank you for the
Yes.
invitation.
Perfect. Perfect. Thank you, everybody. Bye-bye. Bye
Bye-bye.
now.